Good morning, everybody, or good afternoon, actually. Now
Making it
it's
work.
just at 12:30. Thank you for joining us for our latest employment law lab. Um, Before we get into the meat of what we're going to speak about today, I'll introduce myself. I'm Kate Sutherland. I'm one of the senior associates in the team, and I'm joined by my colleague Lee McDonald, who's also a senior associate. A few small housekeeping points. When you join, if you could just keep yourself on mute and just limits background noise for us. If you have any questions, then if you pop those in the chat function, and we should hopefully have some time at the end to cover those or some of those off. The webinar is being recorded today, so if you've got any queries about that, you can look at the privacy notice that is on Vanespol's website. So thank you, as I say, for joining us this afternoon. We're going to look today at what is no longer the Employment Rights Bill, but which is now the Employment Rights Act, it having finally received royal assent in December last year. So we're going to look at what does that actually mean in practice, and we'll look a little bit at one of the changes that was made to the Act later on last year in relation to unfair dismissal. So the change to the qualifying period that's due to come into force and the removal of the compensation cap. We'll also have a look at what else we can expect for the rest of 2026 and then briefly for 2027 and beyond. So the government, as I'm sure many of you know, introduced an implementation roadmap for this legislation in July last year. And that's still in place. So that's still the guidelines, if you like, for when we anticipate various changes to be brought into force. So Lee will touch on today the changes that will come into force as of the 18th of February 2026 in relation to industrial action and trade unions. There are then further changes as of the 6th of April 2026 in relation to paternity and parental leave. Further changes expected in April 2026 in relation to statutory sick pay, for example, and in relation to the protective award that will be available in collective consultation obligations. And then as we move on through 2026, October 2026 is the other key month in 2026. So if we just move on to the next slide, thank you. So we can see there a number of changes that are expected in October, and I'll touch on some of these. So for example, the changes we expect to see in relation to sexual harassment and harassment. You can see there that the time limit to raise an employment tribunal claim, excuse me, is going to increase from 6 months to 3 months. So employees are going to have double the length of time to raise a tribunal claim. And then, as I say, a number of changes expected later on in 2027 that Lee will touch on at the end today. So without further ado, I'll pass you on to Lee to speak about the first changes that we're going to see now that this act is in force.
Afternoon, everyone. So yes, as Kate said, the Act has now received royal assent, and most of the changes under the Employment Rights Act require commencement regulations to bring them into effect, and many even further substantive regulations as well with associated consultation before they can be brought into effect. And so we introduce the Employment Rights Act 2025 Commencement Number 1 and Transitional and Saving Provisions Regulations 2026. Lawmakers love a catchy title. These bring certain provisions of the Act into force on the 6th of January, 18th of February, and 6th of April 2026, respectively. First of all, quickly, the 6th of January provisions didn't really give rise to any employment rights themselves, and that was mostly just to do with the granting of powers to make further substantive regulations and codes of practice, etc., in relation to 0 hours workers, flexible working, family related leave, etc., but not something that you need to put in your diaries, the moment having passed already anyway. But moving on to the next slide. Just before we go into the changes that the regulations have brought into force, it's worthwhile noting in a little segue that while not part of the wordy titled regulations, this actually changed as soon as the bill received royal assent on the 18th of December last year. So the Strikes Minimum Service Levels Act 2023 was repealed as part of the Act, such that as of the 18th of December last year, employers in key sectors, and that's health, fire, transport, border security, can no longer issue work notices to force employees to work during legal strike action. I'm not proposing to spend any length of time on this. I think it's quite rarely used, if ever, but just good to note that what once would have been a good tool available in those sectors to reduce the effectiveness of strike action by requiring people to work anyway is no longer. It's been thought to fly in the face of the right to strike, so hence the repeal. So moving on to slide 8 then, which is in relation to the changes that are coming in the 18th of February 2026 under Regulation 3 of the regulations. While January might have felt like it had 175 days, that's actually now just a few weeks away. And it's pretty much all about trade unions and industrial action. But don't shut off quite yet if your workforce isn't currently unionised, because a lot of the changes actually make it more likely to be so perhaps in the future. So I'll first of all talk through the changes and then have a little think about what impact those might actually have. So taking it in turn, first of all is dismissal protection. That will change such that protection from dismissal, which relates to official and protected industrial action, will be strengthened to provide that both for the full duration of official lawful strike action and after that strike is concluded, an employee will be automatically unfairly dismissed, where the reason or the principal reason for their dismissal is that they took such protected industrial action. Now, previously that was at a very high level qualified to a 12-week protected period from the first date of industrial action, so it's really lengthened that protection. That will apply to industrial action which was begun by the employee on or after the 18th of February, and where it began before that date, the employees will continue to be covered by the previous law. There's also additionally under Section 76 of the Act, which will be enforced, a new right to those participating in strike action, meaning that a worker will have the right not to be subjected to a detriment of a prescribed description by an act or any deliberate failure to act by their employer if that act or failure to act takes place for the sole or main purpose of preventing or deterring that worker from taking protected industrial action or penalising them for doing so. So though this section itself is enforced, it won't actually give rise to any enforceable rights yet until further regulations are made out, which set out what the prescribed description of the detriments that will be all unlawful under it will be. So the government intends to consult on those and bring them into effect around October 2026. So it is something that's more likely to be an issue later this year, but definitely one to put on the radar. There are also a number of provisions which will simplify the balloting and industrial action processes. So Section 68 and 69 of the Act will remove the requirement for a 40% support threshold of eligible union members to be met in industrial action ballots in important public health services, which is health, fire, education of under 17s, transport and border security again. So that's for ballots which open on or after the 18th of February. And in terms of what's meant by opening, it means the first day when a voting paper is sent to any person entitled to vote in the ballot. So that's just the support threshold, so those in support of strike action. The turnout threshold of 50% does remain for now, but keep an asterisk next to that. Section 72 of the Act on ballot expiry. So currently union members' support for industrial action will automatically expire 6 months after the date of the ballot, or if agreed between the union and the employer, it can be extended to 9 months. Once that period has expired, the union then has to hold a new ballot for further industrial action. However, from the 18th of February, that'll be extended to 12 months. Without the possibility of extension. So the increased mandate period will apply to ballots that open on or after the 18th of February this year, and the previous law will apply to those opened before the 18th of February. And so any opened previously will require unions to reballot still to secure the 12-month mandate. Under Section 74, then the notice for action will change. So currently a trade union must provide an employer with notice of industrial action after it's secured a ballot mandate and before they take any such action. So for industrial action to be protected, the union must give the employer a notice covering an appropriate period of 14 days at the moment. The regulations bring into force Section 74 of the Act, which will reduce that appropriate period down to 10 days. And then we've got the additional information requirements on ballots. So currently the voting papers need to include a summary of matter or matters of issue in the trade dispute, questions about the industrial action, and the periods within which the industrial action is expected to take place. But Section 71 removes this requirement. So as a result, the law will revert back to what it was previously, which just requires a trade union to simply ask its members on the ballot paper which type of industrial action they want to take part in. So that's expressed in terms of whether it's strike action or something just short of strike action. And the type of action that a majority of members vote for will then, assuming the other legal requirements are met, be protected and immune from legal action. There are also a few other minor changes, including the removal of the requirement for picket supervisors. So police will no longer have a specific designated supervisor to contact regarding issues on the picket line. There's also certain repeal of the public sector publishing of trade union facility time and limitation on facility time, and particular political fund rules, but I won't go too much into them. Now, alongside this, the government has also published on those trade union measures coming into force a guidance paper titled Trade Union Law Transition to Employment Rights Act 2025. So if you do want to have a look at that, that's worth a read for some practical analysis, and it gives some examples of the timings and things like that as well. So that all being said, the risk of industrial action may increase with the introduction of these parts of the Act, and it'll certainly become more accessible to unions. So we do recommend at this point that HR and operations should probably look to assess the risk of disruption and ensure that contingency and communication plans are up to date and enforced to deal with those changes as well. So moving then to the next slide, which looks at the changes that will be coming into force in April 2026, which is also not that long away, about 8 or 9 weeks with the Easter break as well in between. So from the 6th of April, under the regulations themselves, we'll see paternity leave becoming a day one right. So that removes the current 26-week qualifying period. Additionally, in its interplay with shared parental leave, individuals will now also be able to take paternity leave after taking a period of shared parental leave, allowing parents more flexibility in how they interplay those rights. Importantly, the Act doesn't actually introduce a day one right to paternity pay, so the practical impact might be a bit more limited in the short term. And the changes to paternity leave only apply for fathers of babies born on or after the 6th of April, or whose expected week of childbirth was on or after the 6th of April, but who were born early. As well as that, the ordinary unpaid parental leave will become a day one right, which removes the current 1-year qualifying period for that as well. So collectively, those new day one rights will mean that family leave planning could begin much earlier, effectively so as soon as someone joins your organisation, and as such you might see an increased request in paternal and paternity leave usage. So we recommend that HR and management teams update onboarding processes, training and induction materials so that employees know what their leave rights are. That will obviously include policies, which should be reviewed and rewritten to account for that. And also payroll and HR systems might also need to be prepared. And the processes for approving leave should also be made clear. Managers might require training on that. Leave requests in early employment might not be anticipated by them, given that there'll be a day one right. So the managers might need help understanding how and when to approve leave and what they should discuss and how to manage the potential operational disruption from that as well. So looking at April 2026, aside from the regulations, another very important reform will be to the statutory sick pay provisions. So currently, as you'll likely be aware, only employees who earn above a certain threshold, which is currently about £125 per week, are eligible for statutory sick pay. And even then, the statutory sick pay usually only begins from the fourth consecutive day of absence. However, from April this year, they'll become payable from the first day of sickness absence, and that lower earnings limit as well, which currently excludes some very low earners, will be removed. So with those removed, a broader range of employees will be entitled to sick pay, and more absences will also be paid from day one. So thinking about that from a practical perspective, firstly, and perhaps most obviously, the change has financial consequences. With a lower earnings limit gone, more workers, especially part-time, low-paid or variable hours workers, will become eligible. And additionally, paying sick pay from day one increases costs, particularly if some employees tend to take short absences or one-off days off. So you may want to think about budgeting and planning for the possible increase in sick pay related expenditure. Also, again, payroll systems and HR absence management systems might require updating, including reporting templates, self-certification forms, and manager notification procedures as well. And of course, payroll will need to adjust the calculations so that statutory sick pay is paid from day one. So moving on to the next slide, we've also got the changes to the protective award. So while not, again, provided for in the regs, it's been confirmed that the protective award for failure to consult in collective redundancies will be doubling from up to 90 days pay to up to 180 days pay. That is quite a substantial increase, and raises the stakes for getting collective consultancy right, especially for higher paid workforces and large scale redundancies. It's also likely to encourage a more cautious approach in borderline cases where, employers might opt to collectively consult even where there's some uncertainty or ambiguity as to whether the legal threshold for collective consultation has been met. And really firing through these now. Harassment as a protected disclosure. So again, not in the regulations, but the enhancement of whistleblowing protections by explicit recognition of complaints of sexual harassment will be added as a protected disclosure. So currently, employees who disclose a breach of health and safety obligations or other breach in the law are protected as whistleblowers if they reasonably believe the disclosure is in the public interest. So sexual harassment complaints at the moment can be disclosures for qualify for protection, where they meet that public interest test and they count as a breach of health and safety or other legal obligations, but they are now explicitly called out as amounting to whistleblowing, as long as it meets the test of reasonable belief and it's made in the public interest. And then just a few extra pieces. So there's statutory trade union recognition simplification as well coming through in April. So currently for a trade union's application to the Central Arbitration Committee to be accepted, it has to meet a number of admissibility requirements, one of which is that the Central Arbitration Committee must be satisfied that at least 10% of the workers in the bargaining unit, that's the particular group of workers the union want collective bargaining on behalf of, are actually members of the union. The Act retains the current 10% threshold, but they provide that that percentage can be amended by the regulations to between 2 and 10%. So we're probably waiting on some substantive regulations on that. And it seems unlikely that will happen without those. So it's another TBC on that one. But technically speaking, that will change in April as well. And so that can be expected to come through. And lastly, a new public authority called the Fair Work Agency will, or is due to come into fruition in April, which will bring together the existing enforcement functions of HMRC relating to national minimum wage, the Employment Agency Standards Inspectorate, and the Gangmasters and Labour Abuse Authority. It's unclear when the enforcement powers on that will come into force, but over time, it's intended that the Fair Work Agency will take on the enforcement of a wider range of employment rights. So that'll stretch out to holiday pay, statutory sick pay, and there's flexibility for the enforcement of additional rights to be brought into scope as well. The Fair Work Agency is unlikely to be up and running, I think, probably before the end of this year. Might well take longer than that because the existing agencies will have to be closed down or have their responsibilities transferred. But it's just something to be mindful of because there's a potential for more focused and proactive enforcement once that is in place. And I'll then pass you over to Kate for her analysis on unfair dismissal.
Thanks, Lee. Yes, so unfair dismissal, as I'm sure we all know, Labour had pledged to make unfair dismissal a day one right for employees. But in order to resolve a parliamentary deadlock, they essentially couldn't get that through the House of Lords. They changed to instead reducing the qualifying period for unfair dismissal from the current 2-year period to 6 months. And they also threw in removing the current cap on compensation in ordinary unfair dismissal claims. So that was a new change that I think came about as part of reaching a compromise on the qualifying period point. Now, there is a bit of a tradition of the qualifying period for unfair dismissal being changed depending upon which government is in power. But what this government is doing that's a bit different is that instead of making the change by way of statutory instrument, they're making the change in a primary piece of legislation. And that means that if another government wanted to change it again, they would also need to do so by way of primary legislation, which is a more time-consuming and complex process. So essentially making it harder for a future government to increase the qualifying period again. Now, as Lee said, again, regulations need to be brought into force, as with most of the provisions in the ERA 2025, to actually bring this part of the Act into force. But the government have confirmed that they intend it to come into force, the reduction in the qualifying period, on the 1st of January 2027. And they've also confirmed that they intend to take what they've described as a commencement approach, which means that as of that date, as of the 1st of January 2027, if an employee has 6 months service or more, they would be able to raise an unfair dismissal claim. So, for example, if an employee starts in July this year and then they're dismissed in January next year, and they'll likely be able to raise an unfair dismissal claim. And we expect that this new qualifying period of 6 months will apply where the effective date of termination is on or after the 1st of January 2027. It's worth bearing in mind as well that, as I'm sure many of you will know, that while we broadly talk about a 2-year qualifying period, it's probably more accurate to perhaps talk about a 1-year, 51-week qualifying period. If you were to dismiss an employee with immediate effect, for example, when they have 1-year, 51-week service, then the tribunal will add on the minimum week's notice under statute to give them 2 years service, essentially, to be able to raise an unfair dismissal claim. And we anticipate that that will be the same when the qualifying service is reduced to 6 months. So employees with 5 months, and let's just broadly say 3 weeks service, um, if they're being dismissed at that point and they've not worked their notice, then they could also still pursue, we expect, an unfair dismissal claim. Um, this change doesn't affect the unfair dismissal claims that can be raised at the moment with no qualifying period. So a discrimination claim, for example, arguing that the dismissal was discriminatory, that is still the case. You don't need any service. That's a day one right that you could raise such a claim. So what does that mean in practice then, this reduction in the qualifying period? One area where I think it's going to have an impact is on probation periods and the management of probation periods. So previously, before this change happened, and when we were still expecting a day one unfair dismissal right, there was talk about a particular procedure being introduced for a kind of statutory probation period. So all of that has gone away, but nevertheless, probation periods probably are going to become more important, and the management of those with this reduction in the qualifying period. So many employers will at the moment have a probation period when they first hire an employee, which typically is probably between 3 to 6 months. And if there has been a tendency at times to allow employees to pass their probation, to move past that 3 or 6 month point where they maybe actually aren't quite right for the role, their performance perhaps isn't as it should be, but they're allowed to pass their probation. It's felt the risk is quite low because ultimately, if you're within the 2 year period and there's no other risk factors, like they don't have a protected characteristic, for example, the risks attached to dismissal should be low. Well, that's obviously going to change once the qualifying period is reduced. So I think it's going to become more important to, one, be aware and have a good system for knowing when employees are going to be reaching the end of their probation period, and for those probation periods to be actively managed, for managers to be properly trained in relation to that, so that you don't have employees who are just kind of being able to pass probation at that point and essentially achieve qualifying service to be able to pursue an unfair dismissal claim if they're actually not the right fit for the organisation. So that obviously getting into kind of good probation hygiene now, if you like, is a good idea so that once this change hits next year, processes are already clearly in place to properly ensure that probation periods are being managed. Um, employers might want to think about carrying out an audit of employees who would achieve the requisite service to raise a claim as of January 2027, who might not otherwise, who wouldn't otherwise have service. And if there are concerns about any such employees, there might be a desire to bring that to a head before they achieve service to raise a claim. Obviously, whether there are any other risk factors associated with such a dismissal would need to be considered, such as if they have a protected characteristic. And probably there also would need to be some consideration to any potential reputational damage. So what I'm thinking there is if a number of employees were being dismissed to avoid them obtaining service, and particularly if it's a larger, more well-known employer, you could see that potentially being picked up by the press. But obviously that needs to be balanced against the risk if you do have a number of employees that there are concerns in relation to whether it's performance or whatever it may be, and they're all going to, as of January 2027, be protected from ordinary unfair dismissal. And I think the other probably practical thing would be looking at hiring practices. So again, perhaps carrying out an audit. Are there roles which there's quite a high turnover within the initial 2 year period at the moment? The idea being that you want to get the right people in the roles to begin with, so that you're kind of limiting the impact, perhaps, of this qualifying period, reducing from the 2 to 6 months. So the other change, as I said, that's being introduced by the Act is the removal of the current compensatory cap. So at the moment, if somebody raises just a bog standard unfair dismissal claim, no discrimination or whistleblowing angle, anything like that, then the maximum compensatory award that they can get is the lesser of a year's gross salary or whatever the statutory limit is, and that changes each year. But at the moment, the statutory limit is £118,000, and £118,223 is the current limit. So once that cap goes, and the cap's going entirely, so both of those parameters are being removed. And just as with a discrimination claim, for example, compensation is just going to be assessed on the basis of actual financial losses. And that could significantly increase the potential financial exposure for employers in an ordinary unfair dismissal claim. And the government have said that it intends for this change to come into play in January 2027 as well. Now, what the government have said about this change is that their view of it is that the current cap on unfair dismissal awards are creating a systemic incentive for claimants to bring more complex discrimination claims, which come with an entitlement to uncapped compensation, taking up more employment tribunal time. So it's felt that employees are essentially raising discrimination or whistleblowing claims where they might not otherwise do so, to get access to potential access to a higher award. So we'll see if we do see less complex claims as a result. It does occur to me that in a discrimination or whistleblowing claim, a claimant, if successful, could get an award for injury to feelings as well, that isn't available in an unfair dismissal claim. So there's still potential for them to get more money with those other types of claim. But we'll see if it does lead to more normal, if you like, unfair dismissal claims. Now, at the start of January this year, the government published its latest impact assessment regarding the ERA 25. And that included an assessment of the change to the qualifying period for unfair dismissal and removal of the compensatory cap. And the government estimates that reducing the qualifying period from 2 years to 6 months will protect a further 6.3 million employees, generating an additional 9,000 ACAS early conciliation referrals a year, of which 3,000 will progress to a tribunal claim and 570 will require judicial time. So it's the largest expected impact on the tribunal system of any of the measures in the Act. I'm sure many of you will have or have had claims going through the tribunal system, and will know that it already is under some pressure, particularly so in England and Wales. So I suppose we'll just have to wait and see if there's more resource provided to deal with what is many people think will likely be an increase in claims. One of the other changes that is being made is the period for early ACAS conciliation is being increased. So perhaps that will allow for more claims to be resolved at an earlier stage. The government have accepted that in terms of the impact of removing the compensation cap, it can't actually quantify the potential impact of that. It's referred to the fact that currently most of the compensation awards don't reach the current cap, but arguably that ignores the fact that many employees who are on larger packages don't end up pursuing a claim through the tribunal system because it's not worth their while to do so. So it doesn't mean that once the cap is removed, you wouldn't end up with more high awards being given. So probably where this might be felt most is if we're thinking about senior execs who do have larger remuneration packages that potentially exceed, probably will exceed the current cap, making it potentially harder to agree an exit with such senior execs on mutually agreeable terms because they've got more of an option now in terms of pursuing a claim in the tribunal. So elements of an execs package that might become particularly relevant would be share options, for example, bonuses. So having a look now at contractual provisions around those things, policies, scheme rules, to understand what entitlements there are, what the potential exposure could be, how that might be limited, bearing in mind that what a tribunal will look at is whether the employee reasonably expected to receive a particular bonus payment, for example. Considering alongside any written documentation what actually happens in practice, because the tribunal would look at that too, to determine that question. And is there a disparity between what's written down and what is actually happening? Is there clear evidence about how any bonus criteria, for example, is applied? That could become more important. The other area that's probably going to become more important is around pension loss. So particularly for employees that have good pensions, especially if it's a final salary. Previously, the cap meant that you didn't really need to get into that too much because the cap would just cut that off, if you like. But now there's probably going to be more need to get actuarial reports, for example, to properly assess if an employee has a final salary pension, what that loss is. And there's probably going to be more arguments or more emphasis on arguments around mitigation of loss. So trying to argue that the employee has unreasonably failed to mitigate their loss, which again can be a little bit more difficult sometimes with a senior exec, because naturally the pool of jobs available to them will be smaller than a more junior employee. And these two changes, the reduction of qualifying period and removal of the cap, should be considered together. So obviously, if you have a senior exec who is going to achieve service as of the 1st of January 2027, your potential financial exposure, if they were to be dismissed after that, is going to be much higher than it would otherwise be while the cap is still in place. So other changes then, we're going slightly back in time to other changes that we expect in 2026. So we go to the next slide. Thank you. So fire and rehire, which I think is probably one of the other really major changes that is being made by this piece of legislation. So based on the implementation roadmap, this change is expected to come into force in October this year. But the government had originally anticipated to have a consultation on this in the autumn of 2025, which didn't happen. So we're yet to see if that has a knock-on effect in terms of the timeline for implementing this change. But essentially, it's introducing the concept of an automatic unfair dismissal if the reason or principal reason for dismissal is the employee's refusal to agree to particular contractual variations, unless the employer can rely on the statutory exception of financial difficulty. So that is very different to the situation now, where if you want to make a change to an employee's contract, you seek to agree that with them, you're not able to agree it, you end up dismissing and offering to re-engage. a tribunal, if they're considering that unfair dismissal claim, will look at whether you had sound business reasons for introducing the change and will apply the range of reasonable responses test. But that's all going to go when you're looking at whether or not there's actually been an automatic unfair dismissal. There could just be an automatic unfair dismissal where the particular change is what is known as a restricted variation. So a restricted variation will cover changes to pay, including pension provision, changes to working time and time off, so holidays, also the introduction or amendment of a contractual variation clause, and then any other matters as prescribed in regulations by the Secretary of State. So pretty core terms of employment that will be covered under this concept of a restricted variation. It doesn't seem like there's anything to prevent you from relying upon an existing variation clause to the extent that that can be relied upon in a contract, or from hiring somebody on a new contract that has a variation clause in it. But for existing employees, if you were trying to add one in or vary an existing one, that would fall within the scope of this restricted variation. So what is meant by financial difficulty then? That's the exception. If you can show that actually there's financial difficulty, it won't be an automatic unfair dismissal. It's narrowly defined. It's not enough to be about general commercial pressures or reduce costs or increase efficiencies. None of that would be enough. The reason for the restricted variation must be to eliminate, prevent, significantly reduce, or significantly mitigate the effect of any financial difficulties which were affecting or were likely in the immediate future to affect the employer's ability to carry on the business as a going concern. So the actual viability of the business. Or where it's a public sector employer, other than a local authority, it's about it affecting the financial sustainability of them carrying out their statutory functions. And in either case, if you show that part of it, you also need to show that the employer could not reasonably have avoided the need to make the variation. So it's clear what a shift that is from the current position in terms of the ability to make changes and potentially dismiss and offer to re-engage. If an employer was able to satisfy that financial difficulties test, wouldn't be an automatic unfair dismissal. The tribunal would then consider whether it was an unfair dismissal just on ordinary principles, but it has to take into account certain factors when doing that, such as whether or not the employee was consulted and whether they were offered anything in return for agreeing to the variation. If a change was made and an employee was dismissed because they didn't agree to it, but it's not a restricted variation. So it's just an ordinary unfair dismissal claim the tribunal is considering. They still will need to consider these specific factors that have been set down. Regulations can specify further factors that need to be considered, and the government have said that they will consult on any additional factors before making regulations in relation to that. Just briefly, so Lee referred earlier, obviously, to the change to the level of the protected award, where there's been a failure to collectively consult. And it's just worth remembering that where an employee is dismissed with a view to re-engaging them on different terms, that can fall within the wider definition of redundancy for collective consultation obligation. So again, that increase in the protective award that's going to happen can be relevant here too. And you might be wondering what is happening to the statutory code of practice on dismissal and re-engagement. The previous government introduced that in July 2024. This government have said they're going to update it to reflect these changes that are going to be made under the ERA. And of course, if there's a failure to follow that code, that can lead to any compensation being increased by up to 25%. So clearly the risks associated with dismissal and offering re-engagement will significantly increase once this change comes into force. If there are changes that you're thinking you want to make to employees' contracts of employment, it would be worth thinking about making those before this change comes into effect. It would also be worth reviewing your contracts to see how much flexibility you've got at the moment in the contracts to make changes, bearing in mind that specific language is going to be required for a change to be permitted. Most of the time, general variation clauses can't really be relied upon to reduce someone's pay, for example. So reviewing the contracts to look at more specific language is probably what's going to be needed. If we go to the next slide, I'll come back to non-disclosure agreements briefly. So harassment, as I'm sure you all know, fairly recently, a duty to take reasonable steps to prevent sexual harassment in the workplace was introduced. But under the ERA, that's going to be strengthened further with a requirement to take all reasonable steps, not just reasonable steps, every reasonable step that could be taken. Also, and that's a change, sorry, intended to come into force in October 2026. And the government have said they're going to produce regulations which set out what's meant by reasonable steps. But most recently, the government have said that they anticipate those regulations will come into force in 2027 or 2028. So sometime after the actual duty to take all reasonable steps is due to come into force if that happens in October this year. A new duty is also due to be introduced, also in October, to take all reasonable steps to prevent third-party harassment of employees. And that's in relation to any protected characteristics. So it's not just sexual harassment, harassment of all sorts. So in terms of kind of getting ready for these changes, it's about undertaking risk assessments. So for sexual harassment, looking at things like working hours, staffing levels, social activities, particularly any that involve alcohol. Third-party harassment, considering what are the settings in which our employees are coming into contact with third parties, whether that's customers, contractors, third-party suppliers, and where there might be where there might be heightened risk. So if an employee is dealing with an intoxicated visitor, emotionally distressed service users, lone working, confined physical layouts, documenting any such risk assessments, and of course the action that's been taken to address the risks that have been identified. Making sure that training is up to date. Managers will probably almost always need additional training, and training should never just be done once. It's something that needs to be revisited regularly. Managers need to understand how to deal with subtle forms of harassment, and they obviously need to understand the new duty in terms of third-party harassment. And having records of any attendance at training is going to be important. Recording all of this so that you've got something to show if you were in a tribunal is going to be crucial. And making sure there are robust reporting systems in place. So employees have more than one way in which to report any concerns, and that there's a culture where that's encouraged. Policy should, of course, be reviewed and updated too, so that once this change comes into force, it is expressly dealing with third-party harassment. The tipping that's mentioned there, so there was already an act introduced in relation to tipping, the Employment Allocation of Tips Act 2023. And that was really just to try and make sure that employees are receiving tips in full. They're allocated in a fair and transparent way. And if tips are a regular part of somebody's employment, then there should be a written policy on how the business deals with tips. So the Act is trying to further increase protection there by requiring that before producing a tips policy, there's consultation about that policy with a trade union, or if there's a workers' body representing employees, otherwise directly with the employees. The last we heard was that the government was going to launch a consultation in the winter of 2025 or early 2026, again with a view to introducing this change in October 2026. No consultation yet, so we will see again if they stick to that timeline. And then lastly, non-disclosure agreements. This is actually a change that we don't know yet when it's going to come into force. It's not on the implementation roadmap. But it will make any agreement preventing a worker from making allegations or disclosures about harassment or discrimination, including disclosures about the employer's response to that, void. So such provisions will no longer be enforceable. So that would apply, of course, to settlement agreements, contracts of employment, or indeed any other agreement with the employee. It's not designed to prevent restrictions on disclosing commercially sensitive information or trade secrets. It's about agreements which are preventing an employee from disclosing harassment or discrimination. And the government have confirmed that non-disparagement clauses would be void as well, where they are limiting the employee's ability to speak out about harassment or discrimination. These restrictions won't apply to what will be known as an accepted agreement, and regulations required to be made to set out what is an accepted agreement. The government are going to consult on that first, but it's expected an accepted agreement might be where the employee themselves have asked to have some form of confidentiality, and that there'll be a requirement for them to take independent legal advice. So obviously, this change, once it comes into force, is going to have an impact on settlement agreements, for example, with some of the provisions that might commonly be included now being in whole or in part void, unenforceable, where discrimination or harassment allegations are at play. So that was a slight whistle-stop tour. I'll now hand you back over to Lee just to touch on the 2027 and beyond changes.
Yeah, so appreciate everyone. It's been a lot of information today. Don't want to overload you with it all, but I'll quickly just run through what the roadmap has to say about what's to come into force next year, just to get ahead of that as well. So first of all, there'll be enhanced protection from dismissal during or after statutory family leave or pregnancy. So that's going to require further regulation. Not quite known yet what that's going to look like, but one to keep on the radar. Bereavement leave, and I think there might be a question about this. So the existing right to 2 weeks parental bereavement leave following the death of a child under 18 or a stillbirth after 24 weeks will be extended to an entitlement to more general bereavement leave. So that'll apply to the loss of a wider group of people, and will also include pregnancy loss before 24 weeks. And that will be a day one right as well. Flexible working, an employer will only be able to refuse a flexible working request if it considers that one of the statutory grounds that we know and love at the moment apply, and also with the added piece that it's reasonable for them to do so. So TBC on what that will look like, but just to keep you updated on the flexible working requests, the scope of those are likely to be extended even further, and also reforms to the collective redundancy threshold. So we still don't know what that's going to look like, but that will give the government the opportunity to amend the threshold to trigger collective redundancy consultation. So I just wanted to leave a few minutes for some questions. As I say, a lot of information from us today, and appreciate that as well. But hopefully, that's provided a little bit of clarity and some confidence on at least the upcoming reforms in the short term, and the adjustments that might need to be made in advance of those coming into play. So we do have a few minutes left for questions. Obviously, if we run out of time at the end of today's session, don't hesitate to get in touch with us with any specific questions and we'll be happy to help. But if anyone does have a question at the moment, then we are happy to take those now.
I can see there's been a question asked about fixed term contracts. Um, so so yes, my understanding is it would impact that because obviously when a fixed term contract comes to an end, that still amounts to a dismissal. So now if that's coming to an end when once the qualifying period is reduced at a point where the person would have 6 months service, then my understanding is they would then have the requisite service to raise an unfair dismissal claim. So as you would for at the moment for fixed term contracts which are ending where somebody's going to have the 2 years service and you need to think about either is the fair basis redundancy or is the fair basis some other substantial reason that's going to come into play at an earlier point. Yeah, there's a few more questions coming through. Let me have a look.
Oh, sorry, just from Lisa earlier, there was a question about the changes to paternity leave. Employees must still have the main responsibility for the child's upbringing and be the biological father of the child or the spouse or civil partner of the child's mother. Yes, correct. So all of the other provisions of that will remain the same. It's just those that were discussed that will change.
And somebody had asked what I meant by bring to a head before they reach service. So I suppose what I mean really is where, you know, at the moment they might have been given more, the employee might be given more time to settle in or um, to address performance issues. With the change, it might be felt that actually we want to tackle this and potentially dismiss before the person reaches and gets 6 months service. Obviously, still remembering that you need to think about are there any other risk factors that would allow them to raise a claim with no service? Is there a potential breach of contract claim, discrimination claim, whistleblowing, all of these things? But certainly in terms of ordinary unfair dismissal, perhaps looking at dealing with that sooner rather than later.
Yeah, so as I say, if you do have any other questions that you haven't been able to get across to us today, then do get in touch with any member of the team here with any specific questions and we'll be happy to help with those. And also look out for the Employment Law Lab Bulletin, which will contain a summary of the content we've covered today. And as Maria has mentioned in the chat, a recording of today's session will also be sent out as well.